Ladies and gentlemen, that's 1 o'clock and I'd like to get this pre-examination meeting started. This meeting concerns the forthcoming inquiry into the planning and listed building appeals submitted by Duddingston House Properties and Urbanist Hotels for the proposed change of use, refurbishment and extension of the former Royal High School to form a hotel. My name is Scott Ferry and I'm an Assistant Chief Reporter in the Scottish Government's Planning and Environmental Appeals Division, and with me is Danny On, who's a Senior Reporter. We've been appointed by Scottish Ministers to consider both appeals and report to them with recommendations on those appeals. The Ministers will consider our reports before deciding whether or not to uphold the appeals. Before I go on, I have a few housekeeping announcements. Firstly, can I ask that mobile phones are switched off or at least onto silent during the proceedings? Secondly, there is not due to be a fire test this afternoon, so if we hear the fire alarm, we should leave the room by the main stairs that I guess most of us have arrived by and assemble outside at Parliament Square. I should also mention that today's proceedings are being webcast live and that they'll also be recorded and be available for later viewing on the DPEA website. So that will be a valuable resource for us. The camera will focus only on those taking part in the proceedings, and it's triggered by the use of the microphones. So it's important that we press the microphone button to speak and then press the button again once we've finished speaking. Now, you should each have received a copy of the agenda for today's meeting, but the case officer, Mrs. Kerr, who's sitting up at the entrance to the room, has a few additional copies with her if anyone needs one. Now, I would emphasise that the purpose and scope of today's meeting is purely to discuss the arrangements and procedures to be followed before and during the inquiry. The meeting isn't part of the inquiry and no evidence on the merits of the proposal will be heard or discussed today. We will, however, seek to agree how the inquiry should proceed. Now, moving on to attendance, I'll shortly ask the main parties sitting at the tables to introduce themselves. In the interests of time, I won't ask everyone in the room to introduce themselves just now, but later I'll be asking which of you wishes to give evidence at the inquiry sessions. I'm also keen to get everyone who is here today to sign the attendance list, which Mrs. Kerr has with her, and that will ensure that you are sent a copy of the note of today's meeting. So I'd now like to invite the main parties to introduce themselves, and I'll start with the appellants and then go to the Council before moving on to others. Who's representing the appellants?
Yes, sir. Good afternoon. My name is Gordon Steele, and I'm representing Duddingston House Properties and Urbanist Hotels, and instructed by Anne Falls. I've got a list of witnesses, but I assume you want to take that later in the proceedings, sir.
That's fine, Mr. Steele. Thanks very much for that. And from the Council?
Good afternoon, sir. My name is Craig Welton. I'm a solicitor with Burness Paul, representing the Council. To my right is David Given, Acting Team Manager, and to his right, Carla Parks, Senior Planning Officer.
And Mr. Welton, will you be looking for correspondence in the lead up to the inquiry to be directed to you or to the Council as it has been up till now?
From this point forward, sir, I think it would be better if it could be directed to me.
Okay.
And I'll provide details to the case
to
officer.
Mrs. Kerr.
Yeah.
Perfect. Thanks for that. And there are a number of other parties who have indicated that they wish to participate today. Historic Environment Scotland.
Good afternoon, sir. My name is Peter Ferguson. I'm a solicitor with Harper McLeod and I represent Historic Environment Scotland. With me today are Stephen Robb, Adele Shaw, Andrew Martindale and James Turner.
And again, Mr Ferguson, correspondence should be directed to...
Yes, I spoke to the case officer, Liz Kerr, yesterday and confirmed the correspondence should be addressed to me.
Perfect. Okay, thanks very much for that. Now, turning to other bodies, I'm aware that some may be sitting at the tables facing me. Perhaps I could start at this end and move in the opposite direction.
Sir, my name is Fred McIntosh. I'm instructed directly by the Edinburgh World Heritage Trust and the Coburn Association. And sitting with me on my left is Adam Wilkinson, Director of the Edinburgh World Heritage Trust. And sitting on my right is Marion Williams, the Director of the Coburn Association. We will intend to provide this to witnesses, but we don't have that information yet today.
And again, the question in terms of who the office should be corresponding with from now on.
I will be obliged if you continue to correspond with Marion Williams and the Coburn Association.
Thank you. Mr Innes?
Yes, good afternoon. Colin Innes of Shepherd and Wedderburn, and I'm instructed by the Royal High Preservation Trust, and I have Mr William Graham-Muir with me this afternoon.
Thanks for that. Ms Coburn.
Yes, thank you, sir. My name is Louise Coburn, and I'm a solicitor at DC2 Planning. I'm representing the Architectural Heritage Society of Scotland, and sitting to my left is the acting convener of the AHSS Cases Panel, Dr Elizabeth Graham.
Thanks for that. Now, there were some other bodies who have indicated that they wish to take part. Now, I'd ask other bodies to make their way forward to the microphone just there before they introduce themselves.
Hello, my name is Carol Nimmo. I represent the RRCTMA, the Regent Royal Carlton Terraces and Mews Association, and today I'm also here representing the NTBCC, the Newtown and Broughton Community Council.
And is it your intention, at the minute anyway, that your case to inquiry will be run in tandem with the community councils? It will be a single case, will it?
No, we will be working with the Coburn and the Edinburgh World Heritage Trust. The NTBCC will appeal on their own behalf.
Thanks for that.
Thank you.
Are there any other representative groups with us today? Any individual objectors or supporters that intend to take part in the inquiry itself? Would you mind coming forward to the microphone, sir?
My name is David Black. I can only say I'm here as a citizen, but I have points of law which I would like to present to the inquiry, especially in terms of European law. So in due course I will be presenting that information.
Thanks for that. And no... Oh, there is another individual objector. Sorry, was the microphone switched on there?
No. Sorry, my name's Jocelyn Cunliffe, and I'd like to reserve my position. I'm undecided.
You may wish to participate.
Yes, I may wish to participate.
Perfect. Just so that others are aware, Mrs Cunliffe is the wife of one of our self-employed reporters. Particularly want to make the appellants aware of that. We do not think that that will affect our ability to report impartially to ministers. But just to make you aware of that. Any other individual objectors we think they might want to participate? Okay, thanks very much. Now, moving on to item 3 on the agenda, the 2013 planning appeals regulations set out how appeals are to be determined and include inquiry and hearing session rules relating to the conduct of oral procedure. Both appeals will be considered in accordance with those regulations, and the regulations provide us with the ability to tailor procedures to each particular case, which means that further procedure is required only for those matters or topics where we consider that further information or discussion is required. And there are essentially 4 options open to us: formal public inquiry sessions, informal hearing sessions, further written submissions, or no further procedure where we consider that we already have sufficient information on a particular matter or topic. Now, for anyone not familiar with those regulations, they are available. There's a link to them on the DPEA website, and I'm sure that Mrs Kerr would be happy to assist in directing people to those. Moving on to item 4 on the agenda, our reports will cover the range of issues raised in the appeal submissions, and it's important to state now that all material already before us, including representation letters, will be taken into account in our reports to ministers. Having considered that material, we've concluded that we have sufficient information on a number of the issues, but that we need further information and evidence on others. And the main issues which we think need to be examined in further detail in relation to the appeals are set out in the agenda and are as follows. We think we need an inquiry session to consider the impacts of the proposals on the range of built and natural heritage features which are set out in the Council's decision notices, and that will include consideration of the relevant statutory duties, policies and guidance, including the SHEP tests that are referred to in the Council's reports on handling. Then we think we need a separate inquiry session to consider the benefits of the proposals to tourism and the city economy, and that would include the net economic benefit of the proposed development. And finally, we are proposing a hearing session to consider those conditions to be imposed in the event that listed building consent and planning permission is granted by Scottish ministers, and also any planning obligations or other legal agreements that might be necessary. Important also to state, though, that consideration of suggested conditions doesn't prejudice the eventual outcome of the appeals. So now we'd like to hear the views of those parties who have indicated that they wish to participate in the inquiry sessions on those suggested procedures, starting with the appellants.
Sirs, I can be extremely brief because that would have been precisely my submission to you for a whole series of reasons I can set out, but as a result of your informal ruling or indication, I don't propose to say a word because that's precisely what we would have sought. One small matter, sir, of clarification only on the second bullet point, benefits, etc. I assume, or we assume, that that includes, for the avoidance of any doubt, the viability of the scheme, which is obviously fairly central to us, but it isn't expressly stated, but I think by implication it's there in any event. And in these circumstances, sir, I have nothing to say at this stage, unless you wish me to.
I'm obliged, Mr Steele. Yes, I would say that the scope of inquiry session 2 is widely enough drawn to encompass the viability of the scheme. From the Council's point of view.
Sorry, not a huge amount between us on that. I think that was what largely we would expect. And as far as item 1 is concerned, inquiry session for that seems appropriate. On the net economic benefit topic, we do see the possibility or the prospect of agreement on a number of issues with the appellants on that. And it may be that if we can agree matters with them, the matters in dispute become smaller, and it may be that an inquiry session isn't needed, but I think that would depend on what progress we could make.
That may also depend on the views of others that may wish to participate in that inquiry session. Mr Owen will later talk about the prospect for statements of agreed matters, and certainly that's something we'll be encouraging. reassess the need for an inquiry session, but I think that may depend on others, not just the Council and the appellants. But thanks for your comments on that. For HES.
Yes, sir. Historic Environment Scotland intend participating in the first and third sessions, but not the second. And we agree that an inquiry session in relation to the assessment of the impacts of the proposals would be appropriate, and a hearing in relation to conditions and obligations, again, would be appropriate.
Thanks for that.
Sir, the Coburn Association and Edinburgh Heritage Trust propose to participate in all three sections, but, and broadly speaking, what you're suggesting was in accordance with our thoughts. But I do have one particular thing I'd like to seek clarity on, and that's in respect of the first chapter. While I suspect it's probably included in there, we're quite keen to see assessment directly focusing on the effect on the World Heritage designation of the scheme. I get the impression that it's within that list, but with that reassurance, we'd be content. The other thing is, on respect to the second chapter, the benefits of the scheme would, of course, have to include an assessment of the cost to the city of the loss of the World Heritage designation, and that might be something we wish to cover in that section. And that also would seek some reassurance that could be done.
I think certainly in terms of the first one, the World Heritage Site is one of the receptors that's referred to in the Council's decision notice, so I think there should be no dubiety that we'll be looking to have that covered in inquiry session 1. In terms of the cost to the city, in terms of inquiry session 2, yeah, I mean, I could be persuaded that the scope of that session is wide enough to take that in. And I think it would just be up to you to try and make a case on that basis, and presumably for others to try and refute that.
Absolutely. We'll
entirely relaxed about it, sir.
Great. Thanks for that. Mr. Innes.
Thank you, sir. In terms of certainly agree to the procedures, the Preservation Trust would be likely to participate in matters 1 primarily, but may have an interest in aspects of 2 and seeking clarification on a number of matters in relation to the economic case. I've one preliminary matter on the first topic bullet point, and that relates to the extent to which that bullet point encompasses a full analysis of the relevant policy. And I'm going to put it in the room that we have an alternative proposal which has been part of our objection to this application since the outset. In terms of planning policy and general planning law, competing schemes are not relevant necessarily to each other in the sense of each has to be considered on its merits. However, insofar as policy relating to cultural heritage is concerned, and in particular given the nature of this proposal and the likely effects, it engages particular aspects of cultural heritage policy where alternatives do come into play in a policy perspective. And I would just flag paragraph 142 of the Scottish planning policy, which identifies clearly that enabling development may be acceptable where it can be clearly shown to be the only means of preventing the loss of the asset and securing its long-term future, and any development should be minimum to necessary to achieve those aims. So insofar as national policy is concerned, that is directly engaged by this proposal. And similarly, in the context of Historic Environment Policy Statement published in June, there are aspects in particular, again, where if one looks at the text and the bullet points, alternatives come into play for a consideration. Therefore, in my submission, that first bullet point should be expanded to encompass that particular topic matter to be incorporated in a proper analysis of the full historic and cultural heritage policy assessment.
Thanks for that, Mr. Innes. Mr. Steele, anything to say on that?
Yes, sir. My friend is correct, of course, that what is before you is our scheme for recommendation by you and approval, hopefully, by the ministers. Nevertheless, lurking in the background, sir, like the proverbial elephant in the room, is a possible proposal by the Trust. And if, sir, you feel that there's any relevance to it at all, and I can say now that I will submit in due course that it is utterly irrelevant and has no foundation at all, but if you feel there's any relevance at all, we would much prefer to confront this elephant in the room head-on and ask questions about it and lead evidence about it, rather than have it lurking somewhere behind us. But at the end of the day, it is a matter for you. On the one hand, it is not relevant because what's before you is our application or our appeal, but strictly speaking, that's the position. However, it is there and nobody can deny it, and members of the public are aware of it. So we've got nothing to hide, and would prefer, if you feel it's got any relevance, to hear about it and to cross-examine about the matter as well.
I think we are so minded. Clearly, this inquiry can't turn itself into an inquiry on another proposal that isn't before us. But as Mr Innes says, the application of the SHEP tests require us to have a mind to potential alternative proposals. So certainly when we drafted the scope of inquiry session, when it was in our mind that would encompass consideration of that particular issue, it's good to hear that there's agreement that that's something that the inquiry should properly be looking at. We will consider whether we need to perhaps just be a bit more specific in the wording of the matters to be considered at inquiry session 1.
So just to make it absolutely clear, we would expect the Trust to lead the appropriate witnesses so that they can be cross-examined on this matter, not just snipe from the sidelines.
That wasn't your intention, was it, Mr. Innes?
Far from being it to be sniped from the sidelines. We're more than happy for you to have the details of the application and to have relevant witnesses to discuss the proposal. Certainly, sir.
I'm obliged. Ms Coburn.
Yes, thank you, sir. I'm entirely content with what you propose, save for asking a question related to your most recent comment. Do you intend to issue a procedure notice setting out specifically the topics to be covered in each inquiry session, or will that be covered by the pre-examination meeting note?
The note of this meeting will double up as a procedure notice. Yep, just as it normally would, and in doing that, we'll, as I've said, think about perhaps tightening up the wording of some of the matters. Those others that have indicated that they wish to participate in the inquiry sessions, if you have anything to add on the inquiry sessions that we're proposing, I'd invite you to come forward to the microphone again.
Thank you. Yes, RRCTMA would like to take part in all three parts of a possible inquiry.
And as far as you're representing the Community Council today, can you tell us what their intentions may be?
Not clearly, but I'm sure that they would possibly like to take part and would like to be included.
Now, when we issue the note of this meeting, we'll be giving parties 14 days to give us a definitive response in terms of which procedures they intend to take part in, so that perhaps gives the Community Council an opportunity to firm up their views.
Yep, thank you.
Perfect, thank you. And there was another gentleman who was also wishing to take part. If you'd like to come forward to the microphone also.
Forgive me if I would appear to be sniping from the sidelines, but I believe it's my right under European and British law. So my sniping will consist of drawing to the attention of the reporters those points in EU law which would seem to indicate that a competition which was the results of which were solidified in 2010 came up with one proposal for a £35 million boutique arts hotel. It would now appear that the subject under discussion has nothing to do with that. I'm not suggesting that the applicants to that competition were running on a false prospectus for 1 minute, but I do suggest that there is European case law, there are European directives, and it may be necessary for you to ask the ministers to seek a reference to Europe to clarify this situation, because the case law that I know would seem to indicate that this appeal should be struck out, since it doesn't comply with EU law, as Sir David Edward will remind us, still has primacy.
Okay, thanks for that. Now, it's occurring to me that a line of argument along those lines wouldn't fall really within any of the matters that we are setting out to take by inquiry session. And in that case, I would be recommending to you that you write to DPA now, well in advance of the inquiry session, to set out the line that you would wish to argue. We would afford the parties an opportunity to comment on that and see where we end up before the inquiry session starts.
I will take that direction, but of course you are aware, as an infra-state authority, the system of reporting and its panels is subject to binding European law.
Mr. Steele.
Yes, sir, can I perhaps respond to that? And you'll have to forgive me because I haven't the slightest idea what the gentleman is talking about, either on a factual basis or on a legal basis. But if he wishes to make a legal submission, and that's, it seems to me, what he's doing, I would ask that that is done so forthwith, so that we can look at it and consider it and see if there's any merit in it at all, and if there is, reply to it and respond to it in writing. But we would like to see that, sir, with respect, as soon as we reasonably, practically can.
Yes. So it was Mr. Black, wasn't it? Yes. So I would be saying you really should be writing to us just as soon as you possibly can, and certainly well in advance of the inquiry. And we will give the parties a chance to comment before we respond to you. I think in any event we would want to see something from you within 14 days of the note of this meeting being issued. Perfect. Now, Mrs. Cunliffe, was there anything that you wish to add at this stage? Thanks for that. It seems to me that in considering item 4 on the agenda, we've really covered item 5 as well. So perhaps we can short-circuit things by, if I try and summarise who has indicated that they're likely to participate in particular sessions, and you can correct me if I've got that wrong. So for inquiry session 1, clearly the appellants would be, in fact, for all sessions, the 2 inquiry sessions and the hearing session, we would have the appellant. As far as the Council's concerned, you're looking to, again, participate in all sessions, including the hearing session. Historic Environment Scotland would participate in inquiry session 1 and the hearing session.
Yes, sir, with one proviso in relation to session 2. From experience, sessions such as session 2 have at least the potential to stray into issues concerning impacts on the historic environment. So we would intend having witnesses in attendance for the second session, but would only seek to involve themselves if the evidence strayed into the subject. However, if the session does not stray towards that evidence, then there would be no need for that whatsoever.
Comments on that, Mr. Steele?
Well, sir, that is, if I may say so, a curious position. If they will participate if they see fit, but not otherwise, where does that leave us in relation to asking any questions? Are they entitled to, I use the words again, snipe from the sidelines, but we can't in any way snipe back? That doesn't seem entirely fair. They're either here participating or they are not, would be my submission.
We will be coming on to it shortly, but our intention is that there should be statements of case provided for these sessions. And if that's the case, then it should be possible for Historic Environment Scotland to know in advance what's likely to be discussed or examined at that inquiry session and decide then whether to take part in it or not, rather than turn up on the day, maybe.
Yes, the expectation is that we will not participate because we wouldn't expect that evidence session to consider direct impacts on the historic environment. But yes, we will clarify the position once the procedure note is issued.
So for the purposes of the note of the meeting, would you prefer to reserve your position on on inquiry session 2, and you can let us know in response to the note?
Yes, I think that would be best.
Perfect. I think I would reinforce what Mr Steele has said, though, and that is, I think to pop up at inquiry session 2, you would need to have a formal locus there, i.e. you would need to be putting a witness, at least a witness, forward to give you the opportunity to cross-examine other witnesses.
Yes, I think that's fair, although even having this discussion seems to suggest there is a potential for evidence in relation to the impacts straying into that session. Our position can be clarified absolutely today if such evidence will not be dealt with in the second session.
Are you able to help us with that?
Well, sir, our evidence in the session dealing with economic benefits will fall full square within the second bullet point of your minute. It's as simple as that. And so I'd be extremely troubled if there was any possibility of Historic Environment Scotland turning up on the day without having lodged the appropriate documents and precognitions in respect of which we would do full preparation. And that does not seem fair or equitable.
Mr Ferry, at the risk of sniping from the sidelines, because I'd already raised the issue of the economic impact of losing the World Heritage designation within Chapter 2, I obviously will have to convince the inquiry that it's relevant at some point. But it strikes me that is exactly the sort of issue that HES might be worried about. And so it's entirely possible that I would be trying to raise those sort of issues in Chapter 2. And I only mention that in order to be vaguely helpful, if I can.
Thanks for that. HES.
Yes, I think the question is which session is the appropriate session to consider the potential loss of the status of World Heritage Site. So once we clarify that, then we can clarify the position of HES. There's no suggestion that new evidence will be led. HES's precognitions will deal with all relevant matters. But yes, it would be far preferable to confirm well in advance which sessions witnesses will be participating in.
I mean, I think we've already agreed that the economic results of any potential loss of the World Heritage Site would be fair game for inquiry session 2, and on that basis, you think you would like to take part if such a discussion was taking place?
Not in relation to the economic effects. However, if the only forum in which the potential loss of the status was considered was the second session, then we would intend to participate. We had expected that the potential loss of the status would be dealt with in session 1.
I think there should be no dubiety that the session 1 is intended to consider impacts on heritage receptors. The World Heritage Site is one of those, and if the contention is that the proposed development could result, or could be so serious that it could potentially result in the loss of the World Heritage Site, that sits squarely within inquiry session 1.
Thank you.
That being the case, your position on inquiry session 2.
We have to keep the option open, but we will confirm once the procedure note is issued.
Okay. So for the purposes of recording today's discussion, we can say you're reserving your position on that and you'll let us know within the 2 weeks?
Yes.
Perfect. Yes.
So, in respect of the of those I appear for, we will be involved in sessions 1 and 2 for certainty. I'd reserve my position in respect of Session 3 simply because we'll see what conditions, as it were, the appellants and the Council come up with and take a view, and it's entirely conceivable that we wouldn't then participate. But at the moment, we'll stay in. And if we haven't got anything to say, we certainly wouldn't come along and snipe.
Perfect. Thanks for that. Mr. Innes.
Definitely 1, and may participate to a narrow degree in 2. Thank you.
And not the hearing session?
No, sir.
And Ms Coburn.
Much like Mr Innes, certainly 1, possibly 2, and reserve our position with regard to conditions on the same basis as Mr McIntosh.
Before we move on to the next item on the agenda, is there anything that anyone else... Oh, sorry, I'm forgetting about the Residents' Association. That's because you're sitting... You've said that you would probably want to take part in all 3. Yes, but you confirm upon that in response to the note of the... Yes. And your reservation was about the Community Council's participation. Perhaps you could let them know that they'll have this 2-week window then to firm things up. Perfect.
So just to, finally on that point, in relation to order, we wonder whether there might be an advantage in having the economic issues, i.e. bullet point 2, taken first. The reasoning being that any judgments in relation to environmental issues in the broadest sense must be seen in the context of the extent and weight to be attached to the significant economic benefits that we will argue for. There may be logic doing it that way. We don't feel strongly, but I simply raise that for completeness, sir. That may be a way of dealing with it. It might also be more convenient to other parties who have little or no interest in bullet point 2 that they could come along for the start of the environmental issues and deal with conditions as well subsequently. But I simply raise that for your consideration.
Any other comments on the running order?
Sir, I think the running order as proposed in your note would be the Council's preference. Mindful that the economic benefits are the net economic benefits, and one of the issues that today is already highlighted is the potential economic impacts in terms of the World Heritage Site. I think one more naturally leads into the other, doing it that way around, so that parties can lead their evidence and you can have an understanding on the potential impacts in that way, and then that allows you to approach the economic case from that position. So the Council's preference would be to retain the running order as proposed.
Thanks for that. Any other comments from anyone? Ms Coburn?
Yes, sir, I would concur with what Mr Welton has said. It seems that the natural order in terms of your determination would be to assess the impacts, and if the impacts are then clear in your mind, you would then give your attention to whether or not the economic benefits, as described, outweighed those. So it would seem logical, sir, to take the impacts and then the economic benefits.
Thanks for that. Mr Black.
It's really a personal point. In my own case, I would be unable to attend sessions 2 and 3 because I'll be overseas. And I think the economic benefits are there to be discussed, but I don't think they should be the leading part of the case. I would think sticking to the existing order would be, in my case, would be necessary.
Okay, thanks for that. We're still to discuss timings, dates and so on. We'll be coming on to that later in the agenda, but we take those comments on board. I think we'll give consideration to that, and we'll clarify in our note of the meeting what our thoughts are on the running order. It may also depend on the availability of witnesses on particular days and so on as we approach the inquiry, so it may be something that we leave flexible, but we'll give that some thought and firm up on that in the note of the meeting. So no other comments on the matters to be discussed or participation in the sessions. Okay, I'll hand over now to Mr. On, who will deal with item 6 onwards.
Thank you. Item 6, the dates and likely duration of the inquiry and hearing sessions. We did suggest some dates in the agenda, saying that we were available from 19th September and subsequent weeks. I'd just like to see what the various parties think of that. Mr. Steele.
Yes, sir. As I've indicated, I think to all the principal parties here, we cannot, in fact, for a variety of reasons I can outline if necessary, make the suggested dates in paragraph number 6. In addition, sir, as you will be aware, unfortunately, the main architect of the scheme is no longer with us, and accordingly, in these circumstances, a little more time rather than a little less time would be beneficial to us. We don't propose particular dates, sir, but certainly we cannot make the first 3 years at 4 weeks that you have proposed, and we would seek to accommodate whatever is suitable to you against the background in which we find ourselves.
Thank you. Let's see what everybody else's position first and come back to the dates for the Council.
Thanks, sir. Mr. Steele did advise me shortly before we sat down that the appellants weren't able to make the weeks proposed. We hadn't been aware of that before, unfortunately, but in terms of the Council's position, we can make the work the week of the 3rd of October, and then, unfortunately, it's an either-or for us, on either the 19th or the 26th.
Sorry, I missed that last point.
So it's an either-or, so we can do either the week of the 19th or the week of the 26th, but we can certainly do the week of the 3rd. So 2 of the 3 we can do.
Yes. Yes, it might depend on how much time we need.
Yes.
And we'll come back.
I appreciate that.
Well, okay. Any other views on that before we just... I won't go around everybody, but does anyone want to say anything about particular non-availability, I suppose, rather than availability for Historic Environment Scotland?
All Historic Environment Scotland's witnesses would be available for the 3-week period commencing the 19th. However, there is an issue with availability between now and then for preparing recognitions and topic papers.
Are you suggesting that longer might suit Historic Environment Scotland also?
Indeed, we certainly wouldn't oppose a later date.
Okay.
And the same, I think, is true for those I represent. I was only instructed on Friday, so we would be not in any way complaining if the report, if you, sirs, went with Mr. Steele's concerns and went for a slightly later date.
And Mr. Innes?
We have problems with the first week in September, but not the other 2 dates. But recognising the appellant's position, it looks like we're going to have to look for further dates, which is not opposed.
Yes. Ms. Coburn?
No difficulty either with the dates proposed or for a delay as suggested.
Yes. Any other concerns with dates? Mr. Black, you said you may not be available at certain times. Can you tell me those dates?
Yes, I'll be abroad from probably the 23rd, 24th of September.
Sorry,
so unless you accept evidence by Skype, I don't think I'll be participating in any of the sessions.
Okay, thank you. Ms. Nimmo just nodded that she had nothing to say. Is that right? Thank you very much. Okay, Mr. Steele, it might help if you gave me some idea of how long you think these sessions need to be.
Well, sir, we have discussed this informally, and I wondered if there was prudence in sitting down each session in separate weeks. That is not to say that each session would necessarily last the entire week, but it would give certainty to witnesses who are not involved in one session or the other that their session wouldn't begin until, for instance, the Tuesday of a particular week. It seems, with respect, that the item 1 in your agenda presently, the heritage issues, is likely to last 3 or 4 days. That is the full week. I think probably on the basis of what we've heard, but then we don't really know because Historic Environment Scotland haven't got their minds made up. But it seems probable the economic case might be less than the week and might allow time for conditions or whatever. But my proposal would be, sir, to sit down each session for starting on a Tuesday of 2 separate weeks.
And to save me going backwards and forwards, do you have dates in mind?
The short answer is no, sir, but in the particular circumstances that we're in, the longer, frankly, the better. If it was mid-November or December or, frankly, even later, that would be no difficulty to us, but it depends on your availability and the opinion of others. We're keen to get on with this, but on the other hand, we are in a particular circumstance which is more than unfortunate.
Yes. So sometime this year?
Or early next year even, sir.
Okay.
But not...
Yes. Any views on the duration and possible dates from the Council? Mr Wilton.
Thank you, sir. I'd agree with Mr Steele. I think 2 weeks is probably right. Certainly no less than the full 8 days that would involve, just thinking about the number of witnesses that might be involved. In terms of dates, fortunately, we've checked the dates that were listed. I don't have any information on other dates. I think there is a preference, but I put it no higher than that, if we could try and do it this calendar year or that, but it's no more than a preference from the Council's perspective.
I think in terms of timing, we appreciate the particular situation that the appellants are in, but clearly these appeals are before us. Ministers will expect us to deal with them expeditiously, so I think we would be looking certainly to have the sessions during this calendar year.
Sir, I fully accept that. That's why I said what I did with a slight trepidation, but nevertheless you have our position on the matter.
Okay. Others with views. How far did I get? HES. HES, yes, sorry. Thank you.
Yes, 2 weeks, I mean, it's a reasonable estimate for the evidence. In terms of availability, we do have most of the key HES personnel here today, so we could check detailed availability for witnesses between now and the end of December.
Okay, well, we might do that in a moment. Adjourn and see if we can pin down a date. But before we do so, let's finish the trawl around the table.
We wouldn't disagree with what's being suggested by either the Council or HES in terms of dates and time.
Mr Innes?
Yes, insofar as the cultural heritage matters are concerned, I think an estimate of 4 days may be an understatement. And I think that would be a mistake to just set it down for 4 days, given the number of interests and the potential topics. But obviously I don't think the economic case is likely to last a full week. So I would have thought that the 2-week time period for the inquiry sessions would effectively probably be the right for timetabling, but I suspect the cultural heritage could potentially leak on to more than a week. Insofar as future dates are concerned, we do have an issue with a potential witness in November, and certainly unavailable the week commencing the 14th of November. Apart from that, I think we'd have relatively good availability for a date this year.
Thank you. Of course, your suggestion that we might drift session 1 into a second week and then start session 2 does fall foul of what Mr Steele was saying about being clear that it's got a clear start date. So we'd have to be careful of that, and maybe first week start and then third week for the second session. Maybe.
Sorry, I obviously didn't make my sort of take on that clear. I would agree with Mr Innes in that I think there is a real potential that topic 1 could spill over 4 days, but equally that topic 2 could take less than that, and that overall 8 is correct, or a reasonable estimate, but it might split 6 and 2 rather than 4 and 4. Whether we need to ring-fence specific weeks for specific topics, I think will depend on availability and whether we have the luxury of doing that, to be frank.
So perhaps we might start the second session deliberately on a Wednesday or a Thursday.
Yes,
to allow for that overspill. Yes, okay. Ms Coburn.
Yes, sir. We don't have any difficulty with what's been proposed, other than one of our key team members goes on holiday, and in saying that we were available for the 3 weeks that you had highlighted, we'd just rather assumed that that key team member wouldn't be able to take part. If matters were going to be delayed, then of course he would be back by then, and I'm told that his return date is the 16th of November. So if matters could be set to take account of that, then we'd be grateful. But then equally, you know, we'll fit in with what the greater players around the table are willing to do. In terms of duration, I think it's quite optimistic to suggest that 4 days would be sufficient for the cultural heritage, because I would anticipate a number of witnesses from at least the appellant, the Council on Historic Environment Scotland. I'm not sure that I agree that we need to have 1 week for a particular topic and a second clear week for the economic topic. Like others, I think we can run one into the other. Insofar as a hearing session for conditions, I'd hope that that could be dealt with in half a day. But
thank you. Any other views on timing?
Sir, it certainly would be unfortunate to set down 4 days for the cultural heritage if that is not realistic. Obviously, I have no idea how many witnesses people are going to lead, and I don't know whether you're intending to take an indication of that now. If that were done, that would give a better indication. But if 4 days isn't enough, it would be unfortunate to set down economics for Monday, Tuesday, Wednesday of the following week if that's not going to be realistic. And much will depend on how many witnesses.
Yes.
But I noticed the suggestion so that a week for heritage and a week for overspill oblique heritage and then economics the following week. Whether that's realistic, I simply don't know.
It may be that we won't be able to pin it down sufficiently today to determine that. We may have to revisit that possibly in writing rather than having another meeting. But we'll have to look into that. Mrs. Nimmo, is it?
I think we would much prefer a date to be set today. That's what we thought was going to be happening. I think it would be important that before we raise from the meeting that there is a date in place. I also think it seemed to me that most parties were going to be attending most sessions, and it would be better if it did run straight through without break, whether it's over 2 weeks or whatever. And we would like to see a date today. Thank you.
Okay. Any other views? Right. Let's, as far as you're able to, if you can give some indication now of how many witnesses you might be presenting to the various sessions, that might help us to define it. What I'd suggest then is that we perhaps adjourn with some dates in mind and see if the parties can reassure us that their witnesses and so on will be available. So starting with Mr. Steele, have you given that some thought?
Indeed, we have given it considerable thought, sir, and I can give you a provisional list of witnesses, dealing firstly with the first bullet point, broadly called heritage. We will have an architect from Hoskins Architects, precise identity not yet absolutely certain for obvious reasons. We will have an independent architectural arbiter, Professor Gordon Murray, past president of RIAS, together with a string of qualifications too long to go into this afternoon. We will also have a heritage impact assessment from Andrew Wright, also past president of RIAS, with a similarly long list of qualifications. We will also have somebody from the developers, precise identity not yet decided and rather depends on dates. We will have a witness, Hannah Tweedy, it is expected, dealing with historic environmental assessment issues, and a Mr. Roger Mascall, if I pronounce that correctly, who's an independent heritage arbiter. We will have a landscape architect, Mr. Chris Rankin, and a landscape and visual impact architect and expert, Mr. Mike Wood. We will also have an independent landscape arbiter, Mr. Van Grieken. That, sir, totals 8 witnesses, give or take, in relation to bullet point 1. In relation to the second bullet point, sir.
Sorry, can I interrupt you, Mr. Steele? Just when you're talking about environmental assessment issues and so on there, sitting in amongst the then Historic Scotland's objection to the proposal are some comments about the adequacy of the environmental statement. Are you suggesting that you are seeking to augment the environmental statement, or are you relying on it as it stands but just seeking to bring forward witnesses? Clearly that would have an impact on timings and so on.
That would have an impact on timing, sir, but my understanding is that we're reliant on the information that's before you, and these witnesses will explain it and give evidence about that. I do reserve the position, sir, just in case, but that's my understanding of the position. Clearly, any supplement to environmental information has certain knock-on consequences, but I don't put that before you at the moment. Thanks. Sir, in relation to bullet point 2, economics, broadly speaking, we will have a witness speaking about hotel demand and viability, Mr. Russell Kett. We will have an analysis of alternative use by a director of Cushman and Wakefield. We will have a witness, Mr. Orr, probably in relation to hotel market evidence. He is from Urbanist Hotels. An alternative hotel site analysis by Mr. Letham from Colliers. And we will have a witness, probably Mr. Logan, from Oxford Economics, dealing with economic impact and benefit issues. In addition, sir, we hope and expect that the City Council will lead Mr. Steve McGavin, who was formerly in the Economic Development Department of the Council, but has recently left for the private sector. He was the relevant official in the Economic Development Department of the Council at all relevant times, so we expect him to be led. If, for whatever reason, the Council chooses not to lead him, then we would reserve the position to call him in addition. So that is 5, possibly 6 witnesses on the economic issues, sir.
Would it be possible for you to give us, or give Mrs Kerr, a list of, as you've just read them out?
I will do, sir. I'll have it retyped, because my scribbles are all over it, but it can be supplied to Mrs Kerr, perhaps not today, but tomorrow, if that's agreeable to you.
Thank you. That'd be very helpful. I've got the right number, but I don't know if I've got all the roles fully set out. And for the Council, Mr Wilton.
Thank you, sir. In terms of item 1, I understand that the Council will anticipate leading 3 witnesses. Mr Given, sitting here with me, Mr McMeekan? Thank you, sorry, and Ms Waldron.
Are there specific areas they'll be dealing with?
Mr Given dealt with the planning application. Mr McMeekan dealt with the listed building consent application, and Ms Waldron will speak to landscape and visual impact issues.
Thank you.
On item 2, I'll take the appellant's helpful suggestion to my clients. I don't have a name as yet. As I indicated at the outset, the Council hopes and anticipates that the scope of its involvement in item 2 may be narrowed through agreeing certain matters with the appellants where possible. And I think that will determine just exactly how the Council approaches that issue.
Okay. And for the hearing, well,
I think conditions, sir, would probably be Mr Given and Ms Parks.
Lesser importance, isn't it, in this discussion? Historic Environment Scotland, have you thought about these?
So, sir, in relation to the first session, we would intend to lead 3 or possibly 4 witnesses. The precise individual topics which the witnesses will cover has still to be determined, but we will clarify that in the inquiry statement. And in relation to the conditions hearing session, there would be one witness.
So I wonder if we could have the names of those witnesses, please.
The individuals who will appear as witnesses for all of the roles is still to be finalised, and again that will be clarified in the inquiry statements.
Well, so perhaps in that event I can just raise an issue at this stage. I understand sitting behind my friend is a Mr Martindale. My understanding, and we may be wrong, is that Mr Martindale was formerly with HES but is currently with central government, advising them on heritage issues. And he's, if that is incorrect, I will be told, but these are my instructions. If that is so, issues may arise.
Tell me what you mean by issues. Or...
Well, sir, depending on which department he is in, he may be in a department of central government involved in the decision-making process.
Are you able to help with that, Mr. McMahon?
Sir, Mr Martindale is happy to answer and respond.
Fine.
It's not something I'm aware of.
Thank you, Mr Martindale.
This is the first we've been made aware of this, but I've been in the employment of Historic Scotland and now Historic Environment Scotland throughout the consideration of this application. 12 years ago, I was the National Director of the Architectural Heritage Society of Scotland, but that was before this scheme came forwards. I have not at any point worked in central government.
Is it right that you're now working for the central government? Is that...
No.
No.
Totally incorrect.
Well, if that's incorrect, I'm very relieved, sir.
Good. Puts that one to bed. Thank you. Had you finished outlining the HES witnesses?
Yes, I had.
Yes, Mr.
Yes, sir. At the risk of causing over-distress to Mr Steele, I am not able yet to give names of witnesses, but having had conversations for Chapter 1, we would anticipate in the order of 4 witnesses. It might increase to 5. There's been some discussion in that area. In respect of Chapter 2, I'd anticipate it would simply be 2 witnesses, one of whom, in a sense, would speak to the issue of the viability of the hotel in a broad sense, and the other would speak to the economic impact of the loss of the World Heritage designation. But I'd still need to narrow down availability and these things. I don't want to give names today.
Thank you. Mr Innes?
Topic 1, likely to be 2 witnesses. One, a witness from the Trust, and the second, a witness potentially dealing with cultural heritage issues. I would say that in terms of part of the process of coming to this meeting was finding out who was appearing, etc. And there may be discussions as to whether or not our interests are being taken up by other parties. But as it currently advised, we've proposed 2 witnesses potentially in session 1. In relation to the economic matter, we would potentially have a single witness focused in on a fairly narrow issue if required.
Thank you. Ms Coburn?
Yes, thank you, sir. We would anticipate having 2 witnesses for topic 1. And if we were to take part in topic 2, we would anticipate a single witness.
Thank you. Thank you. Ms Nimmo, I imagine that do you have any idea of number of witnesses? Are you... Okay, Mr Black, if you take part at all, it would be on your own, would it? Representing yourself?
Yes, and obviously given the dates and my unavailability, it would be all by written submission.
Yes.
So
I say if at all because obviously it's a legal issue you're raising and it may be dealt with before we even get to sessions.
it may indeed. I think the Minister may be advised to seek a reference from Europe on that one.
Yeah.
Okay.
Thank you. Okay.
So it's clear that I've seriously underestimated the time for session 1.
That's a lot of witnesses.
And that's 24, give or take, at 3 a day, which wouldn't be too bad in terms of progress. That's 8 days. Therefore, I have to double my earlier estimate from 1 week to 2 for the first or is it the 2nd, but in any event, the heritage topic.
Sirs, just in order to add a note of positiveness to this conversation, there is, I think, a possibility of some overlap, certainly on people sitting on this row of tables, but I don't know that that can be achieved, but we certainly might try to achieve some overlap of witnesses. There's no point having the same thing said 14 times, but so that's a possibility.
Indeed. Do you think that that's something that might be addressed now if we took a short adjournment? And you were
no, we're too far out from checking availability, but it's something we can certainly work on.
It just makes it more difficult if we can't get some idea now of trying to pin down the exact length of time.
I do understand.
I think we should be away 2 weeks. Yes, Mr. Ferry has made a very sensible suggestion, and with which I agree, that it may be that the best thing to do is to set aside a 2-week period for session 1, and then the 3rd week for session 2 and 3, the hearing session, and see where that takes us. With that in mind, is it possible for the parties to go away for a few minutes now? We'll have a discussion ourselves. We'll take a short adjournment, and if you could come together with dates, what are we saying, from mid-November onwards? I think that's more or less where we're up to. If that's okay, let's do that, and it'll give everyone a small break now as well, and come back at 20 past 2. Continue with the meeting then. Thank you. Thank you. Well, I hope that was a useful opportunity to see if we can pin down some dates. Mr. Steele, is any...
Well, sir, my understanding is, of the position of others is that for a variety of reasons, the week of the 14th is not suitable, so the earliest commencement date would be the 21st or 22nd of November, and we would have no difficulties thereafter or into early January, which I know some people have been looking at as well. It may be that some difficulties are going to be flagged up in November or December, but from the earliest practical date of 21st, we are, as things currently stand, perfectly fine.
And from your point of view, an even earlier week is not possible. Is that right?
I understand that due to availability of various other parties, that is a difficulty, and you asked us to look from mid-November onwards, which is what we have done.
Okay, thank you.
Sir, the Council could start in the week of the 14th of November, but unfortunately the Council is not available the week of the 21st. So if we're going to have a clear run, it would be the week commencing the 28th. We've not been able to get hold of everybody, but I do understand we do have a difficulty with the Friday of that week, which is Friday the 2nd of December. But with that caveat, we are otherwise clear right through to Christmas.
Okay. Historic Environment Scotland, yes.
Yes, sir, from 14th of November, the HES team would be available, with perhaps one day being a difficulty for the representative, but we can work around that. And, sorry, that's through until the end of December. I haven't checked beyond December.
Yes, okay. Mr. McIntosh.
As I'm not yet entirely sure which witnesses I have, I can't be completely definitive, but from the 21st of November would be no obvious difficulty. It might be we ask to move witnesses within a week when we get closer to the time, but I hope that wouldn't be too difficult, putting them out of sequence. But we can ask about that nearer the time. I'm hoping that won't be overtly impossible.
Yes, I'm sure we're both keen to accommodate people if we can, if that means rearranging timetables slightly. But the weeks generally are available.
Yes.
Mr. Innes.
Yes, free from the 22nd onwards. but not the week of the 14th.
Yes. Ms Coburn.
Our preference would be from the 22nd onwards.
We seem to be getting a general agreement, which is always nice at these things. Any concerns from the other parties? Mr Nimmo, Mr Black, Mrs Cunliffe. It would all suit you. Okay. Well, it also suits our diaries, I think that's right. Yes. So, 22nd.
Not the council.
Not the council. 28th. Sorry, 28th. So the question is whether we... Well, I don't see any choice, really. It would have to be the 28th and subsequent weeks to suit all parties. So that would be... Is that the Tuesday? The 29th would be the Tuesday.
So I'm just mindful, the council have a real difficulty in the Friday of that week, and if parties were willing and with availability, a Monday start for that week to give us the full 4 days. Because the Friday...
Start on the Monday, you're saying?
Start on Monday the 28th.
Okay.
Because we can't do the 2nd, I'm afraid.
Yes. Unless that's an issue for any parties who might be travelling or... No? The Monday would be fine. Thank you very much. It's much appreciated.
And does that mean so we would not sit on the Friday the 2nd?
That's right.
Which might suit various parties for various reasons, I suppose.
Well, we're not sure whether we might be sitting on other Fridays, so that's an issue. Of course, days like that might be made available for site inspections, which is something I'll come on to again, if they're necessary. Okay.
So 3 weeks.
So that would then be 3 weeks in succession. Any contrary view to that? We can be more precise about the start dates as we go along, but at least we now have a time frame for the whole process. Okay. Any other comments on the dates and the duration of any of the sessions before we move on? Okay, item 7 on our agenda, and the subsequent items are all to do really with the procedures through the inquiry process. We expect there to be prior disclosure of your cases. This helps with the preparation for and smooth running of the inquiry. We look to have structured, consistent and reasonably comprehensive prior disclosure of cases. Everyone should be aware of the scope of the matters raised by others, and that gives us and them and other parties the opportunity to consider the evidence before it's examined in any detail. What we'd like to do is ask parties to provide an inquiry statement as soon as possible, setting out the full a summary of all the principal lines of argument you intend to advance. I would suggest that we do that within 4 weeks of today, and that gives us the maximum time or 4 weeks of the notice maybe when it comes out, but gives us the maximum time available between then and preparing recognitions to resolve any matters, make proper preparation. And that what is included in those statements will limit the scope of what's examined at the inquiry. We won't be too happy for new evidence to be coming out unless it's absolutely necessary. We'd also expect in your statement, as well as the lines of argument you intend to follow, that you give us a list of your productions or documents, we might call them, and witnesses that you intend to call. Any comments on those? On statements, any concerns? Everyone happy with statements of case? We'd then, in terms of the actual inquiry process, follow the usual pattern that parties will provide precognitions in accordance with the rules, no longer than 2,000 words, setting out your case, witness's case. productions in support, we would expect those to be logically arranged, numbered, properly prefixed, so that we know which party they belong to, numbered pages, paragraphs, and so on. We have considered that documents might be prepared and presented and used electronically at the inquiry. Do the parties have any view on that? Is that something we could accommodate? Mr. Steele, would you be happy with that?
Perfectly relaxed, sir, about that. Would you want hard copies as well, or just simply electronic?
Well, we're considering that we might run the inquiry with only electronic documents rather than having banks of files sitting behind us and referring to them. I don't know how convenient that would be for other parties, but would you, as an appellant, be happy with that approach?
Yeah, it does become, or can become difficult, sir, if you're cross-examining and you, a witness can't find the document and the witness is under pressure, etc.
I've found that with hard copies as well.
Well, absolutely, but at least we can hand the witness a hard copy. It's a matter for you if you wish to streamline the inquiry, but I, for one, will certainly be having hard copies, I can assure you.
I think, well, we're intending to work electronically. That's what we normally do. The exception to that would be plans, illustrations, photo montages. We would want hard copies of those, but otherwise we're happy to receive things electronically. I think we would leave it to the parties to agree between themselves, because clearly in submitting documents you'll have to submit to the others, so you can let each other know your preferences. As between hard copy and electronic. We will need one hard copy of a deposit set of documents, which we'll expect the Council to maintain available for public inspection in the run-up to the inquiry, which the Council can then bring to the inquiry and can perhaps be used as the witness set.
Well, indeed, sir. It does occur to me, just as you've said what you did, that of course much is going to depend here on visual impact and therefore hard copies to scale and that can properly be read may be fairly essential in relation to all the montages, wire lines and the likes. That probably will be the bulk of much of our documentation, and there might be some confusion as to what's to be hard copy and what is not. I simply raise that as an issue in this particular case.
Okay. Certainly all the visual evidence would need to be paper copies, and as you say, at an appropriate scale that can be assessed from, established from the drawings themselves. Any other comments on that, Mr Wilton?
Simply so that from the Council's perspective, particularly having to maintain the copy for inspection by the public, hard copies being provided to the Council by other parties would probably be much appreciated. And that may mean actually that we end up with hard copies being circulated around the parties in any event.
Okay, just trying to save some paperwork, but
yes,
as Mr Ferry said, if you want to agree that between yourselves, if you're happy with it electronically. Any other views on that? Okay, thank you. So we'll have inquiry statements produced within the next 4 weeks, and then precognitions probably a couple of weeks before the inquiry sessions begin, with productions 4 weeks, any documents 4 weeks before the inquiry sessions. For the hearing session, we'd like to have brief statements of all the relevant matters that you want to put before us and discuss on the hearing day. Essentially, it's a conditions hearing, so it would be helpful to have an agreed list as far as possible before then. Is that something? Mr Wilson, you'd like to say something?
The Council did submit draft conditions when it responded to the appeal, and it did occur to me when I heard other parties talking about whether they were going to participate in the third session. That would depend largely on where, as they said, the Council and the appellants got to on that. I wonder if, given that the draft conditions are submitted, if as part of the statement of case the appellants could perhaps come back on those conditions, just to give an early view on where we might get to on that.
I think in the normal course of events we would expect certainly the appellants and the Council to be discussing conditions in the run-up to the inquiry and be at the hearing session presenting us with an agreed set.
Absolutely, so I wasn't trying to, I didn't anticipate at all we wouldn't have to be there. It was more about letting the third parties see and then be able to make a decision at an earlier stage whether they need to be there.
Well, it would be helpful to us if they could be involved in that process prior to the hearing itself, and even prior to hearing statements. Obviously, cut matters short if there's a general agreement between the parties. Mr. McIntosh.
So I was wondering whether it would be possible for the Council and the appellants to have reached such a position by the time that the inquiry statement is lodged that we can actually take our view at that point. I know it's not very far away, but one imagines there's been discussions already about conditions, because if we're not to take part in hearing 3, the sooner we're out, the better for paperwork and work for everybody. But the sooner we can take a view, the sooner we make a decision.
Mr. Steele, does
we will
feel that's possible?
We will deal with the issue of conditions as quickly as we possibly can, and I think it should be out with the inquiry statement. It should be a separate process, and I will ask those involved in the process from our end to speak immediately, perhaps even at the end of this meeting, to the Council to establish contact about conditions.
Okay, so there will be a draft of an agreement between the Council and the appellant on what conditions would be appropriate in both appeals, and that can be circulated to the other parties around the same time as the statements of case are produced. Is that
as quickly as possible, sir?
Or even quicker?
Or even quicker. As quickly as possible is all I can say.
Okay.
Council's happy with that, sir. Thank you.
Thank you. That's very helpful. And then, of course, if we can get agreement between all parties before the hearing, we might not even need a hearing session at all. Okay. Just some further requirements and advice on documentation. It would be helpful, I think, in this case. There must be a significant number of documents that all parties might want to put before us. It would be helpful to have a set of core documents identified. Is that something that one of the parties can take on? Mr. Steele, would the appellants be prepared to put that together?
I think normally that would be the Council, sir, but if they will not, I'm sure, subject to discussions, I'm sure that we will take that on.
I think we can obviously discuss with the appellants after this meeting. So I think they may well be well ahead of us in terms of document preparation and order, just looking at their appeal form. I think they might be better placed on that.
Yes, there are a number of parties involved and they each may have their own list. Is it something you're prepared to coordinate?
I think if we can coordinate along with the appellants, I'm just looking at their appeal statement, which is a very long list of their documents and documents that I think would probably fall within the category of core documents. And if they've already done that work, there's no point in repeating it. But if I can pick that up with them after this meeting, sir.
Thank you. Yes. Yep. Okay. Yes, the preparation of recognitions and documents I was referring to earlier, and indeed the preparation of statements and so on, it's likely that we'll, as reporters, produce an outline timetable so that everyone's fully aware of the dates that we've set in mind, and then if absolutely necessary it can be changed along the line. But we'll issue that in due course. It would be useful also to have a statement of any agreement, statements of agreed matters, if we can limit the areas of dispute. We've already had some suggestions that might be arrived at, but if all parties, but particularly the appellant and the Council, can get together and produce a statement of agreed matters, that would be very helpful.
Sir, if it assists, I think one of the matters, particularly in the cultural heritage aspects, is we have a large number of designations and assets, and I would have thought it might be capable of essentially a document being produced that listed the various assets, was able to refer to if there were background reports that underlaid the designation, couched possibly relevant policies that related to it, and possibly where in the environmental statement it's dealt with. rather than every witness having to trawl through that history or that statement, which seems to me largely a statement of fact and possible agreement, that actually could avoid a lot of unnecessary paperwork in terms of witness preparation and statement if that type of document were to be prepared. I just put it forward as a way in which I think that's one matter where I think a lot of effort could be reduced by a little effort up front in identifying the relevant cultural heritage assets, the background documents. A lot of the work's already been done, but having it in a handy document, also cross-reference to the potential relevant policies, seems to me something which might well save a lot of time and effort on behalf of the witnesses dealing with cultural heritage matters.
Yes, that makes sense. Is anybody prepared to put that list or that list together? Does it already exist in some form?
That really should be for the Council. They are the planning authority, sir, by definition, so they surely should know what the designations are.
I think that's fair, sir.
Yeah, would that be sensible then, Mr Wilson, for you to initiate a statement of agreed matters?
Yes, we can initiate
one
that.
of the items on it, and then for everyone to agree or not.
I think the other matter from the appellant's perspective is also, if the parties are prepared to participate in that process, is ruling out matters that don't need to be dealt with, that are potentially not relevant, i.e. The temptation will be to have to deal with everything, but with that type of agreed statement as to the ones that were actually relevant to that particular session. There could actually be a screening element of certain things perhaps being taken out of the process as well.
Yes. As reporters, we might like to have a sight of that in case we did want to discuss some of those matters you all agree on. But yes, in principle, that would be very helpful. Okay. I'll leave that with you for now. Is there any other questions or matters to raise under the topic of documentation, recognitions, statements? Okay.
So I've got two matters that I want to, perhaps through you, to request an update from the appellants. In terms of the visualisations that have been produced, Scottish Natural Heritage did raise issues with them, and there is nothing as wasteful in an inquiry context in debating the quality of images. In terms of, as I understand the position, that the photomontages have been taken using different focal lengths. It may well be that it was a variable camera that was used. I think it would be very helpful if at least a list of the montages were prepared with focal lens and an indication of the extent of view that you're looking at. Because as looking at it online, it seems to me that there is a variable use of focal lengths in terms of the base photography. And that actually means that as it's represented, then they're not directly comparable in scale. Now, I'm sure that you'll be used to working with these types of visualisations through wind farm schemes that you've had to deal with, etc. And ultimately, it's for use in the field. And in this context, at least there's reference points to which you can have scale comparators. But there is that variability, and I think it might be helpful if that were clarified. Because, as I say, the last thing we want is a debate about visualisations. But I think there needs to be a bit of clarity brought to that. And the second, more general point is, in terms of the economic matters that we have raised, I'm just seeking clarification as to whether the appellants are intending to lodge any further material. Are they aware of further material that they're likely to lodge that might be further environmental information or additional information at this stage?
Thank you. Mr Steele, are you able to help us? I know you will be producing an inquiry statement which might set out...
We'll produce the inquiry statement in due course, sir. The short answer is I'll need to take instructions in these matters. I've heard what's been said, and I'll need to look into it and see exactly. It is clear that my friend has some particular fine point in mind, which I don't yet understand, but I'm sure I'll catch up with him soon. But I'll look into it, sir, and we'll get back to him or the inquiry as soon as.
Yes, it might be helpful if, on your first point on visualisations, if there was something in the statement of agreed matters, if there is to be one, which said that visualisations are agreed, that they're whatever they are. Well, anyway, I'll leave that with you. Any other comments on documentation?
So I've got one point in relation to one particular document, but I was going to raise it under item 11, any other relevant matter. I was intending to do it then as a particular document, but I can deal with it.
So not later.
Now. I think it's probably better under 11.
Okay. All right, we'll move on. Item 8 is the procedures for the hearing of evidence. I'm sure most of you are aware of how these things work, but just so that we're clear and for the benefit of those for whom this might be a new experience, the appellant will present the evidence first, then the council, and if the community council takes part, they would follow along with other third parties, I imagine starting with Historic Environment Scotland and then the other represented bodies. I don't think we've got any particular preference for any order amongst other parties that are taking part, and we can agree that on the day, or we can agree it now if you like. But Ms. Coburn?
Yeah, I think with a national remit it might be helpful if AHSS went before those that did not have a national remit.
Yes. Are you talking about our consultative remit? Is that what you're... what do you mean by national remit?
Well, AHSS deals with the whole of Scotland, sir, okay, and has case boards specific to specific areas. This is Forth and Borders, I think I'm right in saying. So therefore the remit of the AHSS is not confined simply to Edinburgh, such as the Coburn Association, for example, or the Edinburgh World Heritage site. So I wondered if it would be helpful to hear from an organisation first with a national remit before moving on to those more specifically focused upon Edinburgh.
Yes, I have no issue with that. Anybody else have an issue with that? So we'll be dealing with Historic Environment Scotland. Are they not a national remit? Yes. Don't worry me. And then you're talking about the Architectural Heritage Society of Scotland following at that point before the local bodies. Yeah, seems a logical approach. I'm not sure whether the Preservation Trust comes in last on that list or somewhere else on the list. But
happy to be last but not least.
So I was going to volunteer to be last as well, but it's really a...
I'm sorry, I missed that.
I was going to volunteer to be last as well.
The flights for the bottom. Yeah. Okay. Well, we'll put a list out, and if there are any issues with that, and certainly if there are issues with timing nearer the event, then we can be flexible as we can. So the usual process, that witnesses will present their precognition to the inquiry, and if there is any need for amending or adding to that in the light of what's been put forward, evidence put forward by others, that can be done at that time. Then there would be then cross-examination, which is being asked questions on evidence by parties who hold a contrary view. Witnesses can then be re-examined by their own advocate to clarify any points made in cross-examination. As reporters, we may have also had some questions on the evidence that you present to the inquiry. In general terms, we will try to seek an efficient inquiry process and prevent any repetitious or irrelevant lines of question, and by encouraging clear and concise answers. At the end of the inquiry process and inquiry sessions, and in accordance with the inquiry session rules, we will be inviting closing submissions. We propose that those are made in writing. That seems to be common practice these days, unless anyone has a particular desire to present their closing submissions orally to the sessions. Okay. And we'll set a timetable for that and agree that at the end of the second inquiry session and confirm it in writing. That will be in the reverse order to the presentation of evidence, which, as is traditional, gives the appellant the final word. We would expect your closing submissions to include a summary of changes in your case in the light of evidence at the sessions, but it's always helpful to me at least to have a brief summary of your case overall. It helps us in preparing our reports to the ministers. Any questions on item 8 of our agenda? Any concerns? We need, under item 9, to look at venue. One of the advantages of this place is that it's compatible with our webcasting, which we intend to continue webcasting throughout the inquiry sessions and the hearing. But we've got no idea whether this will be available. Can you help with that, Mr. Wood? Is it possible, or is it?
If I could comment on that, I think the council chamber is used certainly for a full council on a monthly basis. Yeah. So it may be that would interrupt the.
Any other suggestions for venue? Okay. And as I've said, the intention is to webcast again at that point. It's always the case that the Scottish Government does not provide refreshments at any of these inquiries and hearing sessions, so you're on your own on that, though we might provide jugs of water. I usually ask if there are any awareness of needs, special requirements, and obviously I've been pointed to the needs of Mr Mackenzie, but if there is anyone else who has any particular needs or requirements in terms of venue, please let Mrs Kerr know. Anyone in your parties. In general terms, we would start the inquiry, which I think is now on the Monday, at 10 a.m. We may vary that on subsequent days when we've had a closer look at the programme. I always try to sit till no later than 5 o'clock, but it doesn't always happen that well. But that will be the intention with a 1 hour lunch break.
I have an issue which I'm not expecting to inconvenience anybody else, but every Tuesday I will disappear to lecture the university students on criminal procedure at 4 o'clock, but I'm sure I'll arrange to be covered by somebody at that point.
Right. Well, if there is a particular issue about that, you'll let us know beforehand.
The students are well diaried in, and therefore...
Yes, I understand
they're
that.
not that far from here, but I will try and make sure I coordinate with everybody to avoid it being in the middle of one of my witnesses or something.
Okay. And if it transpires as an important part that you need to be here for, then we'll try and arrange to avoid that.
I'm obliged, but I hope it won't be a problem. I'll certainly try and work it well in advance. Thank you.
And as well as a 1 hour lunch break, we'll be looking for short breaks in the morning and the afternoon. These things have to remain as flexible as possible. We've set aside time, but we will try and be flexible if there are particular problems that people have, or if we need to find more time. We'll just have to deal with that as we come to it. Any questions on accommodation, timetabling? We'll look at that in detail when we open the inquiry and make sure that everybody knows when they're likely to be required and so on. Where would I'm looking under the miscellaneous item 10 now, where would the council place the documents on deposit for members of the public to see?
Ask the question again. Sorry.
We have talked earlier about a deposit set of documents so that members of the public and others can see what's before the inquiry. Where would they be held?
Those could be held at our office at Waverley Court, which is at the foot of East Market Street. And there's a public desk there where members of the public can access documents in the morning.
Mornings only? So in the morning?
It's generally available in the morning. I could check to see whether there would be availability in the afternoons.
Well, I'm not sure whether there's a specific requirement. I think it's just availability.
Yeah.
But if that's what you normally do, yeah. I'm sure we can find the address for that somewhere, but it should go in the notes so that people are aware of it. And as we've said before, that set can then be brought along to the inquiry sessions so that it's available. Turning to site inspections, we've already carried out limited unaccompanied site inspections individually and together in and around the site. We think it would be helpful to do some more unaccompanied inspections before the inquiry opens, and we also think it would be helpful for us to have an accompanied inspection of the site and the buildings themselves before we sit down and talk about them. So that would have to be sometime before the 28th of November. It might be sensible to have it nearer the time so that it's fresh in our minds. So perhaps we could arrange something in the week before. Should we try and put a date down now and work towards it? Would that be helpful? The Tuesday before was that the 15th? 22nd, sorry, no, it's 14th, yes. 22nd? If we can put that down anyway, and if the parties can... I don't think we need to have vast numbers of people going round. We'd need to be accompanied by at least someone from the council and from the appellants. It would be useful if other parties could turn up as well, but not in great numbers, so that all represented and all point out various things. We won't be able to discuss any merits, of course. It's the standard rules on site inspections, but it would be helpful if people are there who want us to take a visual note of certain things if they were there to point out to us. So if there is any issue with those dates, and whoever is nominated to attend could let us know.
So one of the things that's likely to be part of our case is the views of the site from elsewhere within the city. And I hesitate to have all of us traipsing around the city, up Salisbury Crags and round Dale and things on the 22nd. So I might suggest that, would it be possible for parties to put in their inquiry statement places we'd like you to visit in advance, on the hope that you would... We won't send you up our seat too many times, but just in order to ensure that you've looked in that direction.
Yes. It's our hope that the only inspections that we need to do accompanied are on the site itself, and it would therefore be helpful if parties could tell us places they'd like us to go to. Obviously, there are some places which are obvious, but if you want to give us a list, that would be very helpful. We're quite happy for all other parties to go up Salisbury Crags and the like if they wish to, but we don't need to come with you. And anything else? Oh, sorry.
Sorry, can I come in on that? It would be useful to know in advance of the numbers of people that would be likely to be in attendance, as we'll have to make arrangements with our colleagues for access.
And are there any arrangements for getting onto the site, security arrangements, health and safety arrangements?
There may be that we would need to check with our colleagues, and that may be dependent on the numbers of people attending.
Okay. I'm anticipating that we're talking about no more than 2 persons from each of the parties, so I think the numbers will be below 10, or around 10 at the most. 10 or 12.
I don't anticipate that would be a problem. We've obviously had parties of councillors in attendance at the site visit we held in advance of the hearing.
There's still plenty of time, so let's say that must come in no later than with the statements, and the parties can tell us who is going to represent them. If there are issues with dates, then let us know that beforehand. But otherwise,
10 o'clock on the 20th.
Yeah, let's say 10 o'clock in the morning on the 22nd. And then if there's a need for any safety briefings or so on, we've got plenty of time on the day. Okay. Obviously, if events at the inquiry or hearing session mean that we have to make further visits, we'll deal with those at the time, make arrangements at the time. Okay, just a couple of other things before we go on to any other relevant matters. Miss Kerr is here. She's our point of contact, so anything you need to send is through her as the case officer. If there's anybody here who hasn't got her details, she'll be able to give them to you before you leave. I'll also probably add those contact details to the note of this meeting, which we hope to issue that early next week. And as we said earlier, that would form the initial, at least, procedure notice in respect to the sessions we've talked about. Okay, any other relevant matters? Mr. Steele, you had something you wanted to raise?
Yes, indeed I do, sir. Mr. Robert Carr. Mr. Carr is a solicitor and chairman of a firm of solicitors, and he was selected by Historic Scotland and the Council and the Edinburgh World Heritage to chair a series of workshops in relation to the conservation, restoration and development of the Royal High School. He was appointed as an independent and impartial chair, and the workshops took place in 2014, involving the parties I've just mentioned and the developer. One of the main objectives, was to identify common ground between the various parties and no doubt to find a resolution to the various issues. Thereafter, I understand that Mr. Carr produced a report and minutes of his findings, which may or may not contain also recommendations. It may contain observations in relation to the approach and attitude of various parties who were party to the workshops. The report, therefore, in my submission, is central in relation to the approach taken by Historic Scotland, the Council, and indeed the developers in relation to the various issues which are before you for consideration. In short, the report is likely to be, or is certainly, highly relevant to the credibility and reliability of all witnesses, including, of course, the developers. Accordingly, it is my submission that it is essential that the report and the minutes are before the inquiry. The report is said to be confidential and has not been released, and therefore requires the agreement of those who appointed Mr. Carr, namely HES and the Council, and possibly, although I'm not certain about this, the Edinburgh World Heritage Trust, to cause and to authorise Mr. Carr to release that report. Accordingly, I now make the motion that the relevant parties should agree to and instruct the release of that report. These bodies are public bodies and enjoy public funding, and in the spirit of openness and fairness, the report should be made available generally, and it is essential that it should be made available particularly to this inquiry. I submit the public are entitled to know what is in the report, and I say that both to supporters and opponents of this proposal. All should be made fully aware as to the background to all of this, as to how various parties, including the developers, have been seen to behave by Mr. Carr, the independent and impartial chair. So, my motion is that the report should be made available voluntarily at the instruction an agreement of the relevant parties. If they fail to do so, sir, in my submission, two immediate consequences will arise. Firstly, that many may form an opinion as to why public bodies may try to conceal or bury a highly relevant report. And secondly, we will take all appropriate steps as required to secure the production, and that would be a very regrettable step to have to take. In addition, sir, I also make a motion that Mr Carr should attend before the inquiry as a witness, to speak to the report and also to answer any relevant questions that there may be. So in summary, the position is that my motion is that the three relevant bodies, HES, CEC and EWH, should agree to the production of the report and the minutes immediately, and agree that Mr Carr should be a witness before the inquiry. I've flagged this issue up to my friends earlier, and I understand that some, if not all of them, required to take instructions, and I would be perfectly relaxed if they were given a period of reflection to take instructions and came back in writing at a time that you impose upon them, sir, to indicate what their position is in relation to that matter. But if they refuse to do so, sir, we will take further steps, and that would be an example, if they refuse to do so, of unreasonable behaviour. Separately, and I have already flagged this up, sir, we would hope that the Council would lead Mr Logan as a witness, if I've got the name correct.
Mr McGavin?
Whatever his name may be, McGavin, apologies. Apologies, that's my error. Mr McGavin, Mr Steve McGavin, formerly of the Economic Development Council. I think my friend's going to take instructions on that matter, but if he does not, then we reserve the right to call him as a witness as well.
Thank you. Before we ask for the views of the other parties on that, who would you see Mr Carr acting as a witness on behalf of?
Well, sir, we prefer that he didn't act as a witness for us because he is truly independent and impartial. We would strongly prefer that he came as an independent witness to the inquiry, i.e., in a sense, your witness. And it may be that a letter or encouragement from you would cause that, sir.
Let's hear from the Council first.
Sir, Mr Steele's quite correct that we will have to take instructions at this point. It's not something that's been raised with us before, as far as I'm aware. From a look through the appellant's appeal statement, I don't see any reference to this report in there, though I appreciate stand to be corrected on that if it is there. I'm afraid that's probably as much on that point as I can say at the moment. I do understand that via your office a request was made for material to be provided, and the Council provided what it had.
Wasn't the same document that's being sought now?
It might be if the appellants know exactly what it is they're after, if they can tell us in writing, I think that would assist, because there seems to be a certain degree of confusion here as to what's being asked for.
Right. Yes.
Sorry. Carla Parks. I was asked to provide the information by DPA, what we had on our records, and I've searched in our entire records. We didn't have anything. The nearest I could find was a draft meeting note by Robert Carr, which I did hand to the DPA, and that's all we had in our records.
I understand that, and we've followed that exchange of emails. But it seems to be suggested now that Mr Carr has a report or something that he's not even released to the Council. That's what this sounds like, and needs permission from the various bodies that appointed him to release it. Do you know anything about that?
As far as I'm being told right now, there's been no contact from Mr Carr about this, so I'm afraid we'll have to take it away and
now, the
take
suggestion
instructions.
from Mr Steele was that other parties appointed him as well. Was it Historic Environment Scotland? Did have any involvement in that?
Sir, Mr Steele did mention this issue briefly before the commencement of this afternoon session. However, I will need to take detailed instructions on the extent to which Historic Environment Scotland or their predecessors, Historic Scotland, were involved in the appointment or the selection of Mr Carr, and whether they indeed hold a copy of the report. But we would be happy to respond to the motion within a period of, say, 14 days.
Yeah, that seems sensible. Any others involved in this?
Yes, Mr Steele spoke to me, and firstly I observed that the Edinburgh World Heritage Trust is not a public body in that sense. But I've spoken to Mr Wilkinson, who sits with me, and he recollects attending the first meeting. He's not actually aware there is a report at all, but we will conduct an investigation and find out whether we know whether a report was produced, and if we do, whether we hold a copy. It's also been suggested to me that this meeting may have taken place under Chatham House rules, which does, of course, raise some questions that might be said in response to Mr Steele's views on whether it should be made available at all, but I wouldn't wish to preempt that issue at this stage. We'll certainly respond within 14 days to the inquiry with such information as we have.
Anybody else involved in the appointment or the meetings wants to say anything? Mr Steele, have you actually seen this document, or is it something...
I cannot answer that, sir. The document is referred to, sir...
There's some doubt it actually exists, that's all I'm...
Sir, well, let me refer you, sir, to the developer's statement at pages 20 to 25, where we expressly refer to it.
Okay. I don't think we can do any more now than what's been suggested. You've made your motion, it's been recorded. We'll allow the other parties to which you refer to respond to that within 14 days, and we'll take it from there.
I'm obliged, sir. I don't think there's anything else. I'd agree.
And your second point was Mr McGavin. Is that a witness you're intending to leave?
I don't have instructions of that, sir, but I think I'll reserve the Council's position to call the witnesses it sees fit.
And you'll be letting us know that in your statement?
Yes.
Oh, sorry, if my friend could let us know about that, because if he doesn't, we will. And that would be the best evidence of this particular matter, because it was that professional that was involved in all of this.
Well, we'll have to leave that between the two of you, but it would be helpful to know that at the time of the statements. But we have got the luxury that there's quite a gap between those statements and the preparation of witnesses. So I think we can let that one run. Okay. Let me set that note. Just so I've got my note right, Mr. Steele, you said you listed the bodies you thought were involved in the appointment of Mr. Robert Carr. Could you just tell me those again to make sure I got that right?
I believe, sir, it was Historic Scotland, now HES,
yes,
and the Council, and Edinburgh World Heritage. Mr. Carr was not appointed by the developer because the developer allowed these three bodies to make the selection from a short list prepared by these three bodies as to who should be selected. The developer, in fact, paid for the work, but we are not party to the appointment to ensure utter impartiality and independence.
Okay.
And in terms of the request, the developer's statement of the 3rd of September 2015, because I see my friend Mr. Welton is looking anxiously for this. The matter is fully set out at pages 20, 21, 22, 23, 24, 25 about the chairing by Mr. Carr, WSSSC, FRSA solicitor, and the dates of the workshops and the likes. And there it is listed, the three key stakeholders in the project. If he doesn't have a copy of this document, I'll be delighted to supply him with a copy.
Okay. We don't know what's in it because we don't have it. My slight concern is that we're dealing with an application as it is now rather than specifically how we got to it?
Well, it may be, sir, that the matter goes a little further than that, because this might conceivably, possibly go to reliability and credibility of witnesses and evidence. Entirely hypothetically, of course.
Okay. Well, I don't think we can take that any further now. We've set the 14 days to respond. The motion's noted. Thank you. Any other points to raise before we close this meeting? Any other relevant matters? Mr. Wood? Mr. Ferguson, anything from you? Anything from you? No? No? Everybody saying no? All right. Thank you all very much. Anything else from you, Mr. Ferry? Right.